हाँ हाँ
Yes, Mr. Sigdev.
My lord, I want to go through the records, my lord. And the reference is based on ERO report and the report of the border police. In the ERO report, there is no signature. And border police report, the border police says that he is the grandson of a Indian citizen, so he is not a foreigner. So where is the materials of making reference against the person? My lord, so many anomalies in the
You are
yes.
challenging which order?
I am challenging, my lord, The judgment dated 25/3/2007, 26/12/2016, passed in FT case 283/2015.
You are Hussain Ali.
Hussain Ali, son of Asadullah.
How you are related to the FTZ 430?
Well, I don't know, my lord.
Why the record of 430 was called for, any idea?
My lord, as per the last order,
Paragraph number 9.
there are five. There is a order for calling the record of FT case number 430G416, where an ex parte decision is given on 13/3/2018 for tribunal number 4, Gwalpara, and that relates to Hussain Ali, son of Khalil Sheikh of village Lempara. Here, LBO report in our case, as per the record available, we have seen LBO report, Hussain Ali, Khalil Sheikh, Lempara. But based on the same LBO report, the ERO has made reference Hussain Ali, son of Sadullah Sheikh of Bamundanga, and that was without signature. Perhaps, because of these anomalies, ERO did not sign it. So, it's total chaos. How a reference can be sustainable, or the proceeding can be sustainable, order of the tribunal can be sustainable against me based on this anomalous proceeding, anomalous inquiry, anomalous verification report, reference also anomalous. So it's a fit case, to remand the case for fresh inquiry, if there is any case. At least that can be done, There are so many decisions of this on court also. Monora Khatun, Regina Begum, Malika Bibi, so many judgments.
Ms. Verma. Mr. Sigdev, please take this. Look at page number 5, 6, 9, 10, 11.
Five, 6 and 9, Your Worship.
First, look at 5. That's the reference by the SC border. And just mark the case number.
Case number 656 and 556, yeah.
Check where.
And see at page number 9.
5, 6 to 5.
Your old report. Look at the case number.
It will case.
Yeah.
9 to 5.
Bamun Nagar. I have to take this next text to south.
Then 10 to 11.
It will be late. Personally, ठीक है sir.
My verification officer, person ID
Case number 2, serial number is 21.
21.
Yes. 88.
It ठीक है ऐसे या तो 88 है
Yes.
या तो 88 है
88.
38.
He is a citizen of India, sir. Police report for that.
Case number is 88.
No, I said case number.
88. Official case number.
It is 11.
11. 656, 88.
Now look at this case. Another Hussain Ali, but the name of father is different. Village is also-
खोली लोगों ने की
The police will report of police into reference year reference of
পেপার এফাল হ'ব পাৰে সেম নেম না আৰু সেম নেম সেম গাঁও
নহয়
আছে আমি নিজে চাইছো
One is Lempara, one is Ramu.
ইয়া
নহয় এইটো চাওক আপোনাৰ ইয়াতে যি লেম্পাৰা খুলিছে এইটোৰ ওপৰত ভিত্তি কৰিয়ে এইটো ৰিপৰ্ট বনাইছে ইয়াতে নামটো বেলেগ কিয় হ'ব
নাই নাই এইটো ভিত্তিত নাই বনোৱা
The next case just 3. Just
এলবি রিপোর্ট বিশেষ করে ইয়ারও রিপোর্ট বানায় এই
14, 15.
ইয়ারও ফিল্ড না যায়
আপোনাৰ দাদা কি আছে ক'ত ক'ব আমাৰ আমি জাষ্ট ৰেকৰ্ড পাইছো
Mr. Siddhar, Mr. Siddhar will be provided with the record. Let him. Mr. Ali and Ms. Verma. 10, 11.
আছে
11
লাস্ট লাস্ট
10 is the competent authorities reference.
yes
তোমার ইয়ারও রিপোর্ট আছে না আছে ইয়ারও অর্ডারে সেটা সেট এটু অর্ডারে কোন নাম কি এক্সপার্ট এইটো রিপোর্ট আছে এইটো রিপোর্ট আমার লগত আমার এইটো আমার কেস না আমার তো এইটো
page या तो channel का नाम या yes 88 date to show 31 है
Year report.
how you are report to show
When the police.
actually yeah this
Exchanges.
Lordship, the documents have been,
Because there are,
some had to be here, the
if you could see
report,
from the report, Your Honor,
yes,
in page serial number 15, page number 15 of this record, it is the ERO reporting letter, where is the Hussain Ali, son of Khalil Sheikh is there, where the LBO report attached to us, Your Honor,
is
of Hussein Ali, son of
Asadullah.
Asadullah of Bamunda, Your Honor. And the ERO report forwarding of in this case, in here is of Hussein Ali of Asadullah, but the LBO report of got address of Asadullah
Asadullah.
Hussein Ali of Lempare, Your Honor.
A
But
son of late.
There were
Khalid.
LBO reports of both the petitioners, Your Honor, and the ERO forwarding also.
Already ERO reports have interchanged.
Interchange, that's it.
And both the
Because
ERO report says that they are unable to produce document
And
both.
that's whether it has the ERO signature, just verify.
No, Your Honor, in both of them, there is,
No,
in
LBO
this
also.
one,
The LBOs is there,
LBO, is there, ERO
ERO
signature is
nine.
not there. in it.
Better than I.
but
Signature greater than-
difficulty is, see,
Signature better than.
That point of, they never raised before the tribunal.
Tribunal lordship,
These are
exactly.
certain objections that need.
these stages are there because unless there is a reference by the ERO,
ERO, yes.
the competent authority could not have forwarded.
Forwarded.
To the-
It cannot be a mechanical process.
Mechanical.
Now thereafter, the tribunal talking about.
And even the police has forwarded without looking into that. thing.
Exactly. So secondly, the tribunal,
Mhm.
They
even
would
before issuing a notice to the proceedee, should have
look into that.
looked into it. So could have, definitely the proceedee did not raise the issue before the
Yes.
tribunal. But at that point of time, proceedee may not have looked into the.
Yes, even they
file.
fail to,
But it is the duty of the, because it's a quasi judicial authority
Yes, sir.
before issuing notice, he should have been satisfied.
Yes, sir.
Whether it was duly forwarded.
Yes.
And the competent authority forwarded the matter to the, or referred the matter to the tribunal, before that, what should have been done?
at least the signature and seal should have.
That should have been looked into it,
Readily admit.
but this process is bad.
Yes.
We'll clarify one thing, that we will remand back the matter, because after all, they have also certain rights.
Yes.
The reference is not in accordance with law.
No.
Yes.
Subsequent finding, whatever,
Yes.
will also be null and void, right? So that way, we'll remand the matter and then leave it to the authorities concerned to whatever, because he's still a devoter,
Yes.
right? In Buddha, because this is a case, we'll ask the tribunal and competent authority to look into it, because the way it has been forwarded, we do not know, it might have been interchanged in because of Hussein Ali.
Yes, sir.
Maybe it is in the, either in the office of the competent authority or in the
The
office of the ERO, or
Yes.
maybe in the office of the
Police.
tribunal. We do not know at which
Document has
stage.
reached the office of the tribunal, Your Honor, so because
That is, but where it has been,
where it has
We
exceeded,
do
not
not-
exceeded, it is hard to say.
And it's in the
Possible.
same thing.
Same tribunal,
Same
same tribunal.
tribunal
same
lordship.
tribunal, everything, so they might have,
Might have got changed, Your Honor, so while perusing the records.
which stage we do not know. So we'll remand that to this particular petition, will set aside the impugn order and remand back the matter, directing the tribunal to hand over the matter to the competent authority, who in turn will send it back to the ERO. Because without having any signature of the ERO, it has been forwarded to
Cannot
the
proceed,
tribunal.
lordship.
So this
Your Honor, may
process,
make a fresh reference, Your Honor, considering.
definitely, whatever it is,
LBO
leave
report
it
is
to
already
him.
there, Your Honor, against Asadullah.
That it is,
Son of Asadullah.
we'll point out these two mistakes and
Yes, Your Honor.
forward it.
Yes, lordship.
My lord, only submission, my lord, in the event of fresh, my lord, inquiry by any authority. who will be given
Why a
opportunity-
fresh inquiry is required?
LBO report is already there, Your Honor.
See, it's only when matter was forwarded, when the matter was forwarded, there was the reference, the competent authority did not look into it and forwarded the matter to the, referred the matter to the tribunal. He should have referred back the matter, or in fact, sent back the matter to the ERO to put his signature and seal.
Exactly.
From that
lordship.
stage only, we are not on that, it's up to the ERO.
Because he's
We
already.
cannot direct the ERO do this, do that, right? It's up to the ERO who should do whatever, it's up to him.
My lord,
And
if-
at this stage,
if the
lordship-
ERO requires, my lord,
See, who
for
are
verification, my lord, we will
ERO
participate, my lord.
No,
ERO's decision, whatever, would
Yes.
be up to him. Once a fresh adjudication, he wants to fresh investigation, up to him.
My lord, my
Because
lord,
in fact, because see, we are not on that.
my lord, my
We
lord,
want only to the reference part.
my lord.
What the reference is
if I may
there.
submit, Your Honor, in fact, the petitioner has duly appeared before the tribunal and he has
Yes,
presented his case
contested.
on one step.
Yes, lordship.
So the reference is where, as Your Honor rightly directed, so here will provide with a proper verification, annexing the proper verification, he will forward it to the foreigners tribunal. So and he will have to maintain his stand, but now he cannot provide and reprofit his stand, you know that.
We'll make it clear. To remind them. But it'll go back to the tribunal will send it back, send down the matter to the competent authority, and we in turn in hand over it to the back to the ERO.
Yes, sir.
With the, but we'll direct the ERO, the tribunal to interchange the paper.
Yes, sir. LBO's report may be interchanged and the correct
Because that
report.
LBS paper will be interchanged.
Because ERO office doesn't have the LBO report presently with them.
So that is why we will ask the tribunal to interchange the paper, because the LVO's report of this case will be, have to be discussed.
Yes, sir.
The other person, other Hussain Ali is already dead. We have that report also, whom the documents have been exchanged. This court had called for an inquiry report which I'll place before your lordship. That they are
Let,
not
let,
the,
let, 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 let,
Khalid,
it
sir,
be
that
there.
is not in dispute, sir.
no, but
Okay.
if that document, once it gets
Yes, sir.
changed,
Yes.
let
Yeah.
there be clarity on it. Because this court had asked for an inquiry report whether
So
they are one of the
Hussain
same
Ali,
person.
son of Khalil Aske has expired.
He's
He is
expired
expired.
and he had an ex
2013
parte,
he has expired.
he had an
50
ex
years.
parte order against him, lordship.
There is an expertise order.
Yes,
But
lordship.
that expertise order is also bad in law. Because
sir.
he did not discuss anything, simply a paragraph order.
Yes,
But
But
in
they
that
don't
case
come
also
challenging
the,
order. No
they have
one has
never
come challenging.
challenged that order.
don't know what happened at that
But-
point of time, but we found from the, if you read the other file, you will see there is no reasons. As he remained absent, that is the reason he felt the base ground to
And
reject
he
the case.
passed an ex parte order.
But there was a written statement, there was also documents there.
Mhm.
Agreement,
We
huh?
don't have to clear it below the line. We have only one Hussain Ali to go for.
রিমান্ড করিলে রিসিভ ছিলেন আর রিমান্ড করে বুঝলেন আমি কিন্তু আমার পার্টি কিন্তু কন্টেস্ট করার কারণে হেরে থেকে ওটা রেডি থেকে বলি এটা হলে রিমান্ড করে বিষয় আছে
Pass on the record. Put the record.
policy voter দিয়ে মানে লাস্ট কথা উল্টা voter policy order
ইন্স্যুরেন্সের কেসগুলো করেছিলেন তো একটু
রিমান্ড
শর্মার লেখা নেই লেখে দেখেছি
কিন্তু বিকজ
হঠাৎ মিলে দাও
এই লোক কন্টেস্ট করিলে ভাই কন্টেস্ট করছে
Hello.
One and the same person.
into the
India will be different. India will be decision.
দিলেও দিয়ে দেখলি পুরো ডিকটেশন দেওয়ার পিছনে ফাইল করি
আজি আজকে চলবে যদি তার উঠায় না
to this one.
মনে হয়
To order the. This order is not. I don't know why it's not. It's not very well. Nipa, Administrator Stickler, Council appearing for the petition. And will be appearing, you will be there. What's your good name? On behalf of RDPC. MS A. Harma, Standing Counsel, Home Department, for the respondent numbers 2 and 3. Mr. P. Sharma, Additional Senior Government Advocate, Assam, for the respondent number 4. As well as Mr. A.I. Ali, Standing Counsel, Election Commission of India, for the respondent numbers 5 and 6. As per the impugn order dated 26/12/2016, passed by Learned Foreigners Tribunal, Fort Kualpara, Assam, in FP case number 283/2015, arising out of ERO case number 656, 88/38. With regard to the petitioner, Hussein Ali, son of Asadullah, resident of village Bamundanga, Part 2, Post Office and Police Station, Bagwan, District Gwalpara, is set aside in cost. As the reference made by the competent authority, I, Superintendent of Police, Border, Gwalpara, on the basis of the report of the electoral registration officer, though on the basis of the report of electoral, but the said report of the ERO concerned did not contain his signature and seal. Okay, can you clarify? Written letter sentence during the deliberation of the matter. Ms. Verma, understanding Council Home Department, placed a communication under memo number GLP/B/inquiry IN/report/2024/377 dated 08/04/2024 of the Superintendent of Police, Border, Gwalpara, submitting that the Hussein Ali, HOSEN Ali, alias Hussein Ali, son of late Khalil SK, of village Lampara, of number 38 Gwalpara West, LAC, No, there is nothing that he expired.
The first page, the covering letter.
Oh, have expired. 3 to 4 months prior to 08/04/2024. Prior to the date of the same communication dated such and such. Okay. We are keeping this for the time being. We'll give you back.
Certificate also.
Provided the death certificate of Hussein Ali, son of Khalil Sheikh, Your Honor. He expired on 14/11/2023.
We can give it
Uh,
to,
Send,
I'll provide, and the date is 14/11.
just send it by email.
Yes,
We
Your Honor.
can get it.
Yes, sir.
Leave it. Harish Sharma. Yeah. Yes.
Yes, basically, also regarding the medical board. The MC clerkship. The date of appearance of the petitioner lordship was not informed as per information lordship.
Then what happened?
This honorable directed to constitute a medical board regarding the examination of the petitioners, brother, petitioner lordship. And the date of appearance of the petitioner lordship shall informed by the police lordship. And that was not communicated to the petitioner lordship.
the Borpeta to Nikki.
But then going on.
Mental
And
case.
it was constituted for better medical college. Yes, directed to constitute a medical college, PMC.
Providing police and niveau. It is, no?
Maybe because of election, everybody might be busy.
But I had already informed them about this order. The same order can be,
What we will do, we'll just now
changed.
give a fixed date,
Yes,
right? They shall, the police shall,
coordinate Bogaigaon and, thing.
yes, police shall produce him
Borpeta.
before the medical board
Yes,
at GMCH on a particular date.
yes, lordship.
And that before that, the GMCH authority will constitute the board. And
Superintendent of GMCH lordship may
Same.
specifically direct him.
then which police station it was there?
The petitioner police station Manikpur lordship.
Manikpur police station. Okay. Okay. What will you do? Produce him before the medical board on 27th of June. Right?
Yes, lordship.
And then they will submit the report. Thereafter the vacation will be here. And we'll fix it on sometimes around 25th of July. That will be.
26.
26 यहाँ पे Arul report.
No, on 27th,
27th of June, Lordship.
27th, okay. By that time, I think so all election things will be died
Yes,
down.
sir.
And then,
And matter would be fixed on 25th of July
25th of July is the date fixed.
to
Before that-
submit the report and all. 25th of July.
This, whether Mr. Gogoi will be required to be informed.
We'll inform him. A copy may be given to him, Lordship, and I'll also tell him.
Give it to both of you so that you can communicate to the concerned police
Yes,
station. as
Lord.
before.
And Bogaigaon Police and Kamrup Metro will coordinate.
Kamrup Metro will coordinate.
Yes, Lord.
And since this order has been passed in presence of the petitioner, counsel, what's your good name?
MZ Shah.
MZ Shah. Okay,
No, hi. Bogaigaon Police or Kamrup Metro official books. GMC board constitute whoever. Budhok দিদিলে বলতা।
Okay.
No, citizen no call করবেন।
Let's- Detail order, I will, ठीक है?
Order copy may be
Please,
served.
let me give it to you.
Yes, Lordship. No, yes. Yeah.
Your worship, because this matter, the petitioner prays for deportation to Myanmar. Worship, on the earlier occasion, Lordship, I had furnished information, Lordship, regarding
This is order.
it was a communication dated 11/3/24. Lordship, I have not received any updates from the Bureau of Immigration. Your Lordship will give me, kindly give me 1 week's time. I'll just pursue with them.
Mr. Chaudhary,
Lordship.
see, we can give you a short date. In spite of giving you a
Yeah,
long date, nothing has happened. Why do you expect that giving you a short date, something will happen?
Because Lordship will appreciate once it was sent. And the Myanmar government said that he is not a resident of that place. That is,
Now, what will happen if the Myanmar government
so if
doesn't
the-
accept this, then
there's no way out, he says he's from Myanmar. And even, so let us take Lordship, assume he is the petitioner's brother. If he is the petitioner's brother, the petitioner is also from Myanmar. How petitioner's brother is outside? The opening paragraph. of the-
No, that we have,
No.
the thing is this, if the person concerned is from Myanmar, and now tomorrow, another report comes, the Myanmar government saying that he is not a Myanmar, then what will happen?
Lordship, he cannot be allowed to move, the government circular says so, Lordship.
So he cannot be sent back to the,
We cannot deport him to
Right.
Myanmar.
so in that case, what will happen? Continue to be there in the custody, in the detention.
His movements are restricted, that is what the,
Lordship, they can refer him to United Nations Human Rights. Let them take a call and do whatever. They'll give him a refugee status and put him somewhere.
there are instances where persons like the petitioner's brother, a few days back, Lordship, another case had come up before your Lordship, where they wanted to go to another country. They want to go to another country, that's another thing,
That
Lordship.
is in between Afghanistan and Pakistan,
That-
Pakistan or something, but it has been taken over by Pakistan. So that part basically is a country we have just verified.
No, this last case, Lordship, the person wanted to go someplace to Canada. to Canada. Because Canada is welcoming refugees.
So because he has a refugee status, so let them UNHR send him to UNHR.
He might
When
be
they
having,
come.
but what relevance does it have here? Because
You
India is
don't
not a-
reckon- not-
India is not a signatory to the refugee convention.
What will happen with those persons from Myanmar entering into the state of Mizoram?
They have to be kept under detention, Lordship.
The Rohingyas and other people, they are coming regularly. If you go to
In fact,
Mizoram, you'll have to
in
see-
fact, that's a war of words when we are going to fence the border. Mizoram wants that there should be people coming in.
And if this continues, then there may be
That is what.
the state of Mizoram because they have a different identity and different treat, right?
Yes, yes.
Demographically, everything will change that you have seen in Tripura.
Yes, yes, yes.
And how can one keep him in detention?
Well, that is as per
In,
the government circulars, they can, any person who is without any
Yes, but you
passport, no, they cannot be allowed to move free, ma'am.
I know they can't be allowed, but you
So,
have to find
they-
a way out. You do. Report coming from Myanmar is accepting. They're not accepting.
Give them to the custody of the
UNHCR কথা ল'ব লাগিব সুধিবা। আমি কেনেকে জানো তোমালোকে কিয়নো ভাল পোৱা হে তোমাক ভয় থৈ দিম কেনেকুৱা লাগিব
মই বাহিৰত গ'লে মোকো ভয় লাগে।
মই গাজাত নি পেলাই ভয় থৈ দিম বেয়া মানে কথাটো
তাকে দাদত পঠিয়াই দিব। আমাৰ প্ৰব্লেমটো ইণ্ডিয়াত আহি চবে সোমাই পৰে।
এইটো ব্লক কৰিব লাগে না
হুম?
এইটো কিমান ৰিফিউজি দিল্লীত আছে নে ভাবিব যে ৰিফিউজি কলনী
আৰু বাংলাদেশত কিমান আছে জানে? 4 lakhs.
ইমান ৰিফিউজি আছে
Thank you, sir.
আমাৰ detention centerটো মানুহে নাই। আৰু 10টা নে 12টা আছে। হা? বাংগালোৰত 4 লাখ আছে। Only 2.9 lakh আছে। No way. No, that way. Refugee colony is something.
The delivery force is coming to Mr. Chaudhary,
Lordship.
we'll fix it after the summer vacation.
Okay,
And then let us see, let Mr. Chaudhary.
If I may request your Lordship, Lordship will kindly make a mention in the order, Lordship, regarding non-receipt of.
Madam, kindly listen to our order and if something is further to be added, you let us know.
Lordship.
RMS M. Hazarika, and its senior counsel, assisted by Mr. D. Khan, counsel for the petitioner, as well as Mr. R. K. Dev Chaudhary, and Deputy Solicitor General of India for the respondents in the Union of India. As per the petitioner, Muhammad Mohammad, Yashin Yasin, Arafat Arafat is his brother and is from Myanmar, Myanmar, who is presently under detention in Assam, being failed to show any valid documents or is entering into India, including Assam. Earlier, the Ministry of External Affairs, in its BM division, took up the matter to the Embassy of Myanmar, within bracket E, capital E, small o, M, capital M, in New Delhi. Upon verification, next paragraph. The MEA, Minister of External Affairs जो लिखा है वहाँ पे MEA कट देना चाहिए. Was provided which in the report in personal data formats, personal data forms, in respect of 9, didn't make it NINE, illegal migrants from Political Department of Assam by communication dated 12/07/2022, including the brother of the petitioner, Said Muhammad Yasin Arafat, and accordingly took up the matter of nationality verification of the illegal migrants, which EOM in August 2022. In January 2023, EOM informed the MEA that two persons, namely Muhammad Zubair, MD, ZUBAIR, and Syedul Mustafa, SAYEDUL, Mustafa, MUS Stateway, was found that they stayed in Myanmar and the rest of the 7 persons out of those 9 illegal migrants, including Said Muhammad Yassin Arafat, have not been included in the name list of household population census of Myanmar. Next. After receipt of a fresh duly filled up, पहले जो लिखा ना पर्सनल रखा फॉर्म वहां पे PDF कर दें PDF with complete address relating to the residence of Said Muhammad Yassin Arafat. It was in March 2023 forwarded to the UM for nationality verification. And the response from the UM is still awaited. The reminder was issued to the UM in February 2024. By communication dated 11/03/2024, the Ministry of Home Affairs, Government of India, in its Foreigners Division, apprised the court that the status of nationality verification of Said Muhammad Yassin Arafat is awaited from the EOM. Today, Mr. R.K. Devsudri, Learned Deputy SCI, DYSJ, submitted that the authorities concerned in the Ministry of External Affairs as well the Ministry of Home Affairs, within bracket Foreigners Division, yet to furnish him such nationality verification report of Said Muhammad Yassin Arafat. Considering the above, the respondents in India in the Ministry of External Affairs, as well as the Ministry of Home Affairs in its Foreigners Division, allowed further time to place the national verification report, nationality verification of Said Muhammad Yassin Arafat to be received from the Embassy of Myanmar. List on. Twenty-third of July, ma'am,
Yes.
23rd of July.
Okay.
Copy of this order be furnished to Mr. R.K. Dev Chaudhary, learned DYSGL for his necessary use.
May I please lordship kindly pass over the method for today due to some medical emergency, my senior left the court.
Mr. Sharma, will you able to tell us what is the fate of this particular proceeding petitioner? Look, see, the tribunal declared him to be a foreigner. Learned single judge uphold it. Preferred this read appeal. There is no such stay order. Because stay order has to be for with regard to the order of the tribunal as well as the order of the learned single judge. There is no such order in this read appeal. So whether the petitioner is under detention or
I will inform the sir.
uh, if the petitioner is under detention and the appellant seeking time,
Yes,
no problem. But the appellant is free
Next
can
week,
understand.
lots of immediate road.
and you'll be surprised that it was a case of 2006
Yes, lots of.
before the tribunal.
Mm.
So 18 years have gone by.
It's lots.
When
Next week, any date lots.
court,
Yes, lots.
right,
Yes, yes. Lots.
placed on court for hearing
But I put. This one good.
on the prayer, the matter is adjourned on the prayer of the council for the appellant, Mr. M. U. Mahmood. List on court.
Lordship, in this case, Lordship, Mr. Ekulta was supposed to argue in this case, Lordship. But due to some difficulties, he could not able to appear today, Lordship. So I have taken the consent from the other side, Lordship. Can it be on 4th of June, Lordship?
Thus, any difficulty on court?
Yes, sir.
Yes, Mr. Sharma, tell us what to do. Counsel for the petitioner.
Earlier, B Sarkar was appearing, Lordship.
Hmm?
Earlier, B Sarkar was appearing, Lordship. And notice was issued on
One Mr. Bosishto Sarkar,
yes,
who don't know him. Then one Mrs. P. Basfor. The difficulty is in their filing slip or in the writ petition as well as in their Wakalatnama, they did not provide their communication numbers, telephone number. Now, the stay is in force
yes, Lordship.
since
21. Okay.
4th of May 2017.
Yes,
So after 7 years, see, when the matter was taken up for hearing, none appeared. We can vacate the stay,
yes, Lordship.
but why should the proceeding should fall for the face the hardship for the non-appearance of the council? Why should the proceeding? Because it is not proceeding's fault, it's the fault of the council.
Otherwise, Lordship may appoint amicus curiae, Lordship.
Difficulties we don't know. Normally, we always inform if somebody is not there. The names are there, if somebody's telephone number is provided. What we have seen, nothing.
Yes, Lordship.
Verma. Roera, telephone back. What happens if we engage some amicus?
Hmm.
Day after tomorrow, again the council.
Yes,
appears.
Lordship.
Then
Earlier
we have to
happened,
relieve. We have
Lordship.
done on many occasions, we have to done that.
Yes,
That's why we do not like it.
if your Lordship vacant this stay order, then immediately he will appear, Lordship.
But what will happen?
Yes.
But the proceedings will suffer for the fault of the
Yes,
lawyer
Lordship.
engaged by her.
Yes.
But there is a letter, what we have seen in the record.
Hmm.
From the railway LP school.
Hmm.
The. Its headmaster. So, there he had written, he had the photocopy with his signature.
Hmm.
The admission register.
Hmm.
The procedure took admission in the LP school at Bongaigaon, India, 1963. But difficulty is 1963, she was already 13 years.
Yes, yes.
And normally LP school it is up to class, at that point of time, it was only up to class 3.
Yes,
LP
Lordship.
school was up to class 3 at that point.
Yes, Lordship.
So. Don't know.
Hmm?
The finding of the tribunal is that the proceeding did not prove those documents.
Yes, Lord.
That is why the. Lady. ফুল নামটা দেখলে উপকার। বাষ্প বাষ্প। None appeared for the petitioner. On call. Do. Names of 2 councils have been reflected. In the cause list. On behalf of the petitioner. He was for. There will be the number of votes. List on 6th. For hearing. Let's just look at the petitioner is an interim. Protected since 04/05/2017.
May I please your lordship. My lord, I am for the appellant, my lord. I am sorry, my lord. Today, my lord, my senior is facing some difficulties, my lord. May I pray for adjournment of the case for the day only, my lord.
On various occasions, we have taken time, my lord. This one run 13, my lord. 2000 is the petrol pump, my lord. I will distribute to me.
April 28, 2018 or not?
I don't know, but
Then
what is this? Interim order is in force.
Yes, my lord,
since
since 2018.
2018, there is a limit
And
of
my lord,
everything.
and very interestingly, my lord, in this case, my lord,
For the last chance, my lord.
writ petition was allowed. In fact, writ petition was allowed, and respondent number, my lord, he is not even filed affidavit. So, my lord, and my lord, point is, my lord, that on the date of application, my lord, that certificate which was given by the leaser, my lord, that he is I am the absolute owner, my lord. Actually, he is not absolute owner on that particular date.
Effective.
The defective application, my lord, that on that ground, my lord, writ petition was allowed.
Tell us up to you.
My lord,
Tell us up to you. Because what we have seen on various grounds, see, basically from 23rd of July 2018, there was no intention on that part. That it will take so much time, which almost 6 years.
my lord. No, we are always ready, my lord. Actually, that point is very small, my lord. And by that point, my lord, how they can, my lord, it will be on the basis of the record, it was passed, my lord. There is no averment, my lord, denying our allegation, my lord. And that is because of the status quo order, my lord, they cannot proceed now.
You have also not filed any application for vacating stay.
No condition, actually, my lord, matter was supposed to be heard. That is why, my lord. Suppose, my lord, you lordship vacate the stay order. Even then, my lord, they cannot because case is pending. Because they will not go again for a law of loss.
Tuesday,
My lord,
Tuesday.
Tuesday. Anyway, my lord, it has to be heard by DB2, my lord. Because it
Lordship
is
is
assigned by your lordship.
Recusing from
Yes.
this because there are, we know the reasons.
My lord.
So
But our ground is that only that, my lord, that of application, my lord, he is not
Tuesday.
eligible. Court, man.
Mr. Jay Segar, counsel appearing for the appellant. On the ground of his senior. Counsel, Mr. VC Das. It is seen that this appeal was admitted way back on 23/07/2018, and since then the interim order is in force, staying the interim
status
order
quo.
passed by the London single judge dated 14/5/2018. On a number of occasions, this matter also was adjourned earlier on the prayer of the appellant. As agreed by the parties list on that to party.
Yep.
Single ones, single as a two. হেৰি কৰিলে দুটা বজাত বহিম বাৰু এই তেওঁলোকৰ নম্বৰবোৰ আছে ফোন নম্বৰখিনি আছে ইনফৰ্মেশ্যন কৰি দিয়ক 12:15 বজাত দি দিয়ক নহয় তথাপি ইনফৰ্ম ৰাইজিং অফ বিডিপি তেওঁলোকৰ ফাইলকেইটাত নাম্বাৰ দিব পাৰিম 12:15 Yes, Mr. Sharma, kindly tell us. Mr. Dekar, take your seat. We are in the court of law, right? Now you tell us. What is the provisions of Rule 3(1)(12) of the 2017 Act? Kindly read. Now it has two parts. One part is the Dice Code 2019, and there is also a requirement of physical verification of the last 3 years. The last 3 years, as we mean, is the last 3 years means from the date of coming into a previous 3 years, from the date of coming into the effect of this 2017 Act. Now, during the physical verification, the number of students was found less than 100. Whereas, as per the DICE data from 2019, now this requirement of additional teacher in a particular school, ME school talking about, is in the basis of 2 counts, right? One part is DICE data 2019 and prior to that, and the second part is physical verification. So here is a case, while in physical verification for the last 3 years, that is from coming to the effect of 2017 Act, they're less than 100. And prior to 2009, there are plus 100 plus. So what do you have to say? Now, just tell us the reverse situation. There are less than 100 prior to 2019, and there are 100 plus prior to 2017. Then what will happen? Burwa. এই পুরোনো education একটু। Mr. Sharma, come to the schedule. Schedule is as per the Right to Education Act. Now, see the schedule, what is the requirement? Hmm. One teacher for science, one teacher for social studies, one for language. Right. Then so one teacher for every 35 children. So 35 for each. So here in this particular school from the year 2017-8 to the previous 3 years. 2015-16 there is 76. So how many? Why 105? Where from you got the 105? Each means what? Three teachers for these 3 subject teachers is important. There has to be minimum of 3 teachers. It is 25 or whatever. But at least one teacher for every 35. So every 35, there has to be 3 teachers, one mathematics and science, one is language, and one is social studies. This is a must. But it doesn't say 105. Where from you got it 100? Because 35, 35, 35. Same. Then already they have said subject, there has to be one teacher for this and this and this. So there has to be minimum of 3 teachers. Hmm. लिखो। Heard Mr. P.K. Dekar. Land Council appearing for the review petitioner of writ petition. Also heard Mr. P.N. Sharma, Standing Council. Education Department. For the respondent numbers 1, 2, 1, 2, 3. Mr. B. Gogo, Standing Council, SSA. For 4 and 5 or for 4? And Mr. Saikia, you can appear for government. P. Saikia. Government Advocate Assam for the respondent number 5. The petitioner preferred a writ petition being WPC number 1347/2023. Tara, what is the sentence? Tara, what is the sentence? The petitioner since March 2004 was serving as an assistant teacher in Biraj Mohan Kumudini Dr. ME School in Goripur Education Block, District Dhuri, since its venture stage. The said ME School was taken up for consideration for provincialization under the provisions of the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017 as amended. The name of the petitioner was recommended by the District Scrutiny Committee for Provincialization as an assistant teacher, as a language assistant teacher within bracket Assamese, for provincialization of her case under the said 2017 Act relating to said ME school. But the state level scrutiny committee did not consider her case for provincialization of her service and recommended only 3 teachers from the said school for provincialization. Aggrieved with such action on the part of the state respondents in the education department, the petitioner filed a writ petition being WPC number 1347 of 2023. Stating that considering the number of enrollments of students in the said ME school, there is a requirement of one additional post of assistant teacher, and therefore our case should have been considered by the authorities in the school department for provincialization of her case as provided under section 3 within bracket 1 within bracket Roman 11 of 2017 Act. Prior to the filing of say WPC number 1347 of 2023, the petitioner earlier preferred a writ petition being WPC number 4670 of 21 with similar prayer. The court, by an order dated 16/09/2021, disposed of said WPC number 4670 of 2021, remanding the matter to the state respondents in the school education department to examine the case of the petitioner, particularly the Director of Elementary Education Assam, as to whether the said school is required to have an additional teacher and in that circumstance, considering the enrollment of students in it, and in that circumstances, whether the case of the petitioner can be considered for provincialization under the say 2017 Act. In addition to the 3 teachers already provincialized. Dispose of liquidation 16,920. Pursuant to the said order of the court dated 16/9/2021, passed in WPC number 4670/2021. The Director of Elementary Education Assam considered the case of the petitioner, but rejected her prayer and claim for provincialization, finding that the said ME school has less than 105 enrollment and has less than the 105 enrollments of students. As there is a requirement of additional teacher only after if there is enrollment of students is more than 105. Agreed by the said finding of the Director of Elementary Education dated 19/11/2022, the petitioner preferred the second writ petition being WPC number 1347/2023 noted. In WPC number 1347/2023, the petitioner placed before the court that as the District Scrutiny Committee recommended her case for provincialization considering the number of enrollments in the school, for the years 2015, 2016, sorry, 2014, 2015 and 2006, at an average of 105.23. And therefore, the respondent authorities in the school department of the Assam committed illegality in rejecting her case for provincialization as an additional teacher of the said ME school. In the writ petition, WPC number 1347/2023, the respondent authorities placed before the court the order of the Director of Elementary Education Assam dated 19/11/2022 to show that the said ME school during physical verification for the year 2016-17 and 2017-18 was found only with 86 and 79 numbers of enrollments. Which are less than 105. thereby no requirement for an additional teacher in the said school. The court, while disposing of said WPC number 1347/2023 in its order by order dated 15/03/2023, indicated that the petitioner failed to place the numbers of enrollment of students in the said ME school as per the data recorded in DICE code of 2009-10 and before, requiring provincialization of an additional teacher in the said school at the relevant point of time. And considering the same, the court in its order dated 15/03/2023 uphold the rejection of provincialization of the petitioner uphold the order of the Director of Elementary Education Assam dated 19/11/2022 relating to the rejection of the prayer of the petitioner for provincialization of her service as an additional teacher in the said ME school. The petitioner filed this review petition stating that the court, while passing the order dated 15/03/2023 in WPC number 1347/2023, committed illegality since there was the number of enrollment in the said ME school during the period from 2009-10 and prior to that at more than 100 students, 105 students. And therefore, the finding of the court that court dated for idea. The numbers of enrollment of students in the said ME school recorded by DICE that code of 2009-10 doesn't envisage for any additional teacher in the said ME school at a relevant point of time is bad in law. We have called for a report from the Sarva Shiksha Abhiyan Assam to specify the number of enrollments in the said ME school during the periods prior to 2009-10 and thereafter till date, till the order of till provincialization of the said school. The respondent SSA Assam through its mission director on 08/04/2024 filed an affidavit specifying the enrollment numbers from the year 2006-7 to 2020-21 as Annexure 1 to the said affidavit. From the said report of the SSA Assam, it can be seen that the concerned ME school had enrollments of students of 129 numbers in the year 2006, that's 2007, 128 in the year 2007, that's 2008, 133 in the year 2008, that's 2009, 120 in 2009, that's 10. Roman 1, 2, 3, 4, 91 in the year 2010, that's 11, 102 in the year 2011, that's 12, 107 in the year 2012, that's 2013, 101, that's 2013, that's 2014, 101 in the year 2014, that's 2015, 76 in the year 2015, that's 2016, 86 in the year 2016, that's 2017, and 79 in the year 2017, that's 89, 2018. $107 in the year 2018, that's 19, 106 in the year 2019, that's 2020, and 101 in the year 2020, that's 2021. However, from the year 2021, that's 2022 onwards, there is no DICE data pertaining to the enrollment of the said ME school. As in the meanwhile, the said ME school has been amalgamated with, which is the base school. Amalgamated with a base school, namely BAS, Silarai Academy ME School. And the teachers whose services have been provincialized under the teachers of said ME school, the Biras Mohan Primary School. The services have been provincialized as tutors. 3 teachers will under the 2017 Act has now been utilized in this said base school, namely Silarite Academic Image School. The provisions of section 3(1) within bracket 11 of the 2017 Act, as well as the provisions of section 3(1) of the within bracket Roman 12 of said 2017 Act were considered and stipulated in the order dated 15/03/2023, passed earlier by this court in WPC number 1347, 2023, which are reiterated here again for I debate with them.
as per the provisions of Section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009, and a schedule provided in the said 2009 Act, for an ME school, for class 6 to 8 class school, the requirement is silo. Is 30 test. Already. Since the requirement is that one science and mathematics teacher, one social studies teacher, and one language teacher, altogether 3, is must for such an ME school for consideration and for provincialization under the said 2017 Act. Accordingly, the 3 teachers from the said ME school have already been considered for provincialization and provincialized as tutors. No doubt that during the year 2019 and prior to that, the said ME school had the enrollment of terracotta sentence. As per said schedule of 2009 Act, there is also requirement of one teacher for every 35 children. Thereby, 3 teachers for 105 children in such ME schools. No doubt. The said ME school had more than 105 enrollments prior to 2019. But as required under Section 3(1) within bracket 12, Roman 12 of the said 2017 Act, the enrollment of the said ME school was verified as per DICE data of 2000. No. And the physical verification of students and checking of records of attendance of the students of last 3 years. In the last 3 years, as provided in Section 3 within bracket 1 within bracket 12 of said 2017 Act, means the previous 3 years from the date of coming into the effect of say 2017 Act, The 2017 Act came into force with effect from which date? 16th May 5th May or 16th May? Hmm? Wherefore you are saying? 5th May 2017. Hmm? There's a notification of 12th May 2017. Except section 4 and 8. Section 4 and 8 has not yet been notified. I don't know it has been notified thereafter or not. It is not available in the book. But the rest of the provisions of the 2017 Act came into force with effect from 5th of May 2017. Fifth of May 2017, except section 4 and 8, as per the notification of the state government and the education department dated 12/05/2017. PMA लिखिए number detail PMA.375/2017/44 dated 12/05/2017. Since such physical verification of the last 3 years prior to 05/05/2017, the committee found that the school had less than 105 numbers of enrollment. The Director of Elementary Education Assam, in its order dated such and such, rejected the claim of the petitioner for provincial election, additional teacher, i.e. that of the petitioner in the said ME school. By our earlier order, passed on 10/5/2024, the state government in education department was asked to clarify its stand. And by communication number E488467/24, dated 29/05/2024, the Secretary Government of Assam in the Department of Education provided that the requirement of an additional teacher in ME school as per the provision of say 2017 Act relies upon two provisions. One is section 3(1)(11), another is section 3(1)(12). That is, the enrollment should be verified with the data as per the DICE code of 2019 or before. And the physical verification of students and checking of records of attendance of students of the last 3 years. since on physical verification of students and checking of records of attendance of the students of last 3 years of the said Kumudini Bharatiba School, along with the enrollment of the said ME school as per the DICE code of 2019 and before, as there was least number of students in the said ME school, less than 105 number of students will be provided in their 2017, 18, 2016, 17, and 2015, 16, okay, 15, 16 per year. This court is of the view that there is no such illegality or infirmity with the order dated (1911) 2022 of the Director of Elementary Education Assam, rejecting the case of the petitioner for provincialization of her case as an additional teacher in the said Biraj Mohan Kumudin Datta ME School. Accordingly, this review petition without any merit stands dismissed. Yes, Mr. Sharma, you are supposed to. Whoever.
May I plead, my lord? My lord, before going to everything, my lord, we have to see one thing, my lord. The petitioner before your lordship, claiming that she is the daughter of Dulal Mia and Anwara Begum. Dulal Mia and Anwara Begum, my lord. And the sole evidence of her link is the testimony of projected mother.
Yes.
And brother and one uncle, my lord. So that is the only point, my lord. Now, before going to that, my lord, she is relying on the statement of DW2, that is my lord, projected mother. My lord, if your lordship may kindly see page 30, this is the voter list of 1977. Probably the particular is it page 31, that is not clear. Particular is it page 31.
Yes.
And I'm relying on page 30 because the 31 is not clear in my page, in my copy, manner. The projected father is Dulal Mia, serial number 174, my lord. And he is son of Aki Ali. Aki Ali.
Which voter list you're talking about?
Page 77, my lord. Page
Which
30.
voter list? Year.
Year is, my lord, 1977. voter list.
Serial number is something is there, 23455.
Yes, that is, but in the, my lord, the translated version at page 30, that's why I'm not It is not clear in my page, my lord.
No, what is the number we do not know because we have seen 2, 3, 4, 5. It should be 6. Okay. Before what 2, 3, 4, 5,
Yes,
6
yes.
we do not know.
Yes, yes. Probably 3, 4, 5, 6, 2, 3, 4. In the vernacular, my lord, it may be 4, my lord. Dulal Mia.
Hmm.
Dulal Mia. Son of Du.
Ake Ali.
Yes,
Ake Ali.
Ake Ali.
Hmm.
Aged about 40,
35.
35 years. And projected mother is Anwara Begum, wife of project probably Dulal, aged about 28 years.
Hmm.
Now, this is the voter list of 1977. my lord.
Hmm.
Now, if the mother was my lord, mother was 28 years in 1977, my lord, her date of birth will be sometime in 1949.
Hmm.
And she was eligible to cast vote in the year 1970.
Hmm.
Because if she was born in 1949, after 21 years, my lord, she would be 1970. So 70, 71, her name should be there in the voter list, and she should be a voter in 1970, 71. Similarly, my lord, the father,
Hmm.
projected father, Dulal Mia,
Hmm.
he's shown to be, my lord, aged about 55 years in 1977. So his date of birth will be sometime in 1942, if we calculate. It may be 1, 2 years, my lord, here and there. And she was eligible to cast vote in 1963. So these two are the main documents, my lord. And another thing, my lord, probably the Amina is projected to be grandmother, my lord. Amina was aged about 40 years in 1977. And she was, if that is correct, my lord, her date of birth will be sometime 1937. And she was eligible to cast vote in 1958 itself.
Hmm.
Now, this is the voter list, first voter list and first document in the name of the petitioner's father
Hmm.
and mother, my lord. Prior to this, there is not a single document in the name of father, mother, and grandmother, my lord.
No difference is between the father and grandmother is only 5 years.
5 years.
Hmm.
Only 5 years. Now, why I am pointing this out, my lord?
Hmm.
The petitioner is relying on the statement of Anwara Begum, who was 28 years in 1977, and
Hmm.
whose citizenship is not confirmed by this my lord, voter list of 1977. At least she should show who is coming for giving an evidence that I was there in the India prior to 1971, that this is my documents, this is my voter list of whatever documents my. Her existence in India prior to 1970 was itself is doubtful, because she could not produce any documents of herself to show that she was in India prior to 1971. So one person whose existence in India itself is doubtful, and she will come and say that I am the mother of so-and-so, so she is an Indian. How can we believe that, mother? First of all. So first of all, the person who is coming for giving evidence, her identity, her citizenship should be, my lord, confirmed by any documents, my lord. That has not been confirmed. She could not produce any documents. She has, while giving evidence, she has only provided, my lord, the voter ID card. Voter ID, which is, my lord, which is issued in 2015. Now, my lord, they may argue that, my lord, in 1977, the Ake Ali is the, my lord, grandfather, and who is the son of Muhammad, is it about 60 years. Why I was showing this 1977 voter list, your lordship may kindly see, they have, the petitioner has produced the voter list of 1965 only, prior to that. Page 28 is the 65 voter list. And there, it is, the projected grandfather name is Akel Ali. Akel Ali son of Muhammad Ali. Akel Ali, son of Muhammad Ali. But aged about 53 years. But interestingly, my lord, in 1965 voter list, neither the grandmother, nor the son, the projected father, is appearing along with that projected grandfather. Now, who will say, my lord, this Akel Ali, son of Muhammad Ali, and Ake Ali, son of Muhammad, is same in one person? Their age is also different. Age,
Basically,
my submission is that, my lord, the tribunal cannot presume that this Akel Ali, son of Muhammad Ali, is 53 years, whose name was appearing in 1965, is same Ake Ali, son of Muhammad is about 60 of 1977. That presumption cannot be drawn by the tribunal.
Mr. Ali, can you please be clear, because earlier in similar circumstances, there was a background. Why I'm asking you this question. One case, while I was in the other side, Planet Senior Counsel, H.R.A. Chaudhary was the counsel for the petitioner. The matter was before His Lordship Honorable Justice H. Roy in a particular court, in the old building of post. Then they produced a list of particular candidates before the court. And then court accepted it, that list, selected. Somehow, for a reason, I had a doubt, that list. And in the department which I was representing, also the well-known department, many things used to happen at that point of time. And in fact, everything appears to be true. So I just prayed before the court that should give me some time, because there is a doubt, and the Lordship asked me what is the doubt. And I clarified. That is why I'm asking you this issue. Then after all, the court considered it, and some time was given. Then we got it, the report in original from, it was the district of Goalpara. So you got to say it's a fake one, because the top and the down portion is there. Here in most of the cases, we have noticed, which we are asking you only. This has been issued by the electoral officer. Now, in most of the cases, we used to see this line, come to page number 31.
31.
You see, there is a line down below.
Yes, not a
Just
legible
before
copy.
certified to be true. Do you have, Mr. Sharma, are you holding the original?
Yes.
There's a straight line, just before copied by, then certified to be true, then site core, there is
Yes,
a
sir.
line there. Have you noticed?
Yes, sir.
And there is also
Box,
line
sir.
at the top,
The box.
that line box you will see,
Yes, sir.
after 1, 2, 3, 4.
Yes, sir.
So these lines, sometimes it happens because of the photostat machine, it's possible. Because in printing also, we have seen such kind of printing, sometimes such line
They
comes.
make
But
box.
this, if you look at it, you'll see it has been from this page number 31, I was just talking about.
Yes, sir.
Something is there, appears to be replaced by something. And thereafter the signature or obtained, because round signature down below is again same, it is round seal has been made after the copying it. So what is them, you just verify from the original one. Original is available probably. I do not know whether it is the record there is original. This is not in the case of this particular matter. most of the cases we have seen, because we used to provide you the photostat copy.
Yes, sir.
And these lines, after that 1, 2, 3, 4 block in the top,
Yes, sir.
and just before the Shaikhar of M.A. Hussain, whatever.
Again, this is a
was,
line.
Then there is always 2 lines are available. Is it in the main copy also? Is it a certified copy?
Yes, sir.
Is there such lines are available there?
Yes, sir. It is like making
Then-
a box.
That is why,
Yes, sir.
if it is been given by the authority, the electoral registration officer or election officer,
Yes, sir.
then why this is required?
It's not. I have to confirm it also because it seems because in the Word format, while typing it out, they made certain, because I also think in various petitions, there used to be a format of box here. For every particular thing, they used to make this box, even in while filing petition in DRT, and all I've seen this format of using box. So whether if it has been done by the department itself.
You come to page number 35, it will be more clear there.
Yes.
35.
Yes, sir. Yes, the box is there.
Why this box?
Oh, yeah. But in all the certificate copy they produced, Your Honor. These boxes are in.
You're copied and pasting it from somewhere or?
Yes. They must have pasted it here, therefore they have made the changes, Your Honor, while preparing this certificate. And the format has been prepared. But it just come and paste it and thereafter they enter and make the relevant changes.
Anyway, forget that. Maybe it's a format or whatever.
So my submission is that, my lord.
Hmm.
The petitioner fails to show that father and mother were there prior to 1971. So in absence of their presence in 1970, prior to 1971 in India, apart from the other aspects, my lord, the statement of Anwara Begum, who is claiming to be the mother of the petitioner, cannot be accepted.
So you want to say that the existence of Dulal Mia and Anwara Begum.
Madam, I'm leaving aside Dulal Begum, Dulal Mia
No.
for the time being, my lord.
Okay.
Yes.
For the
Anwara
time being,
Begum.
Anwara Begum's existence in India prior to 71 itself is
Doubtful, madam.
doubtful.
Not clear by.
Because the DW to Anwara Begum did not exhibit any such document of her presence in India
Prior to
prior
1970.
to.
So when her citizenship itself is doubtful, her statement has no value, ma'am.
Her statement as a
As
to
a
prove the link between
yes.
the proceedee and
the
her projected husband.
husband.
This
And
is one line of your. argument.
yes, that is one line of the argument, my lord. Secondly, my lord, the projected father was also not there prior to 1971.
Just like the Anwara Begum.
Yes, even though petitioner, my lord, somehow managed to establish herself
Hmm.
to the father of the petitioner, Dulal Mia, then also the petitioner has to establish that Dulal Mia was a citizen of India, who was there in India prior to 71. That is what Honorable Apex Court in Para 26 in Sabananda Sunwal says, my lord. Para 26 clearly says, my lord, the petitioner has to give evidence of number one, his date of birth and place of birth. Number two, my lord, the citizenship status of the parents. Here, the citizenship status of the parents is not proved. They have not brought any evidence to show that the Dulal Mia and Anwara Begum was a citizen of India, and accordingly, being daughter of Dulal Mia and Anwara Begum, the petitioner is a citizen of India. That is one point, my lord.
Okay.
And the, my lord, second point, my lord, the Akel Ali, whom the petition, and Ake Ali is same in one person, that has to be proved by any evidence.
So you want to say that 1966 put a list of Akil Ali,
Yes, son of
son of
Muhammad Ali, is it about 53 years?
Hmm.
My lord, he's,
of 1965.
yes, 65.
The same person of Akil Ali, son of Muhammad.
Muhammad, who is 60 years in 1977 or not. If it is the same person or not, that has not been proved by any other evidence. So, in the instant case, my lord, the petitioner has to prove directly that she is the granddaughter of Ake Ali. Akel Ali, whose name was there in 1965. Not Ake Ali, son of Muhammad of 1977. She has to prove her lineage to Akel Ali, who was there in 1965 as and son of Muhammad Ali, is it about 53 years.
Okay.
Because the 1977 is a post-71 document. So even though she established her link to this 77 documents, my lord, it will not give any relevant, it has no relevancy because it will not provide her any benefit. She will not get benefit of that. She will have to prove directly that she is the granddaughter of Akel Ali, son of Muhammad Ali, who was 53 years in 1965, with 65 documents. Now, the discrepancies, my lord, apart from that, discrepancies in the names and ages of the, my lord, projected father and mother, my lord. Your lordship will find 77. The father is Dulal Mia, son of Ake Ali, is it about 35 years. Again, in 1993, the Dulal Mia become Dulal. Dulal, son of P. Behel, son of Behel, sorry. And he become just 1 year older from 1977 to 1993. So he is just 36 years become just 36 years in 1993, who was 32 years, 35 years in 1977. Father name is different. His name itself is different. Instead of Dulal Mia, it become Dulal. Similarly, the Anwara become wife of Dulal here, my lord. Wife of Dulal, aged about 32 years. So she has become elder just 5 years. 29, 4 years, my lord. And these are the only voter list of the projected parents, my lord. Thereafter, from 1993, the petitioner has not produced any documents of her. 97 is there. 97, it is Anwara, my lord. 97, it is Anwara, wife of R. Dulal. And here she is saying, along with Hokor and Idris. Anwara here, my lord, become just 55 years. So from 1977 to 1997, after 20 years, she become 20, from 28, she become only 35. Only 7 years. We have to mind it, my lord. Its husband name is R. Dulal.
Right, we have seen that.
Yes. So from all this, my lord, these discrepancies, they have given the petitioner to, my lord, clarify all these discrepancies, file an affidavit, show moto affidavit, saying that these are wrong, this is wrong, this may be, which is not, my lord, which cannot be accepted as a piece of evidence in the court of law. That I will submit the judgment of this honorable court, my lord. Now, she has produced a my lord, school certificate as Annexure Exhibit 1, my lord, which was not proved, in fact, which was not proved. Exhibit A1 was not proved. That is the school certificate, my lord. And the school certificate, father name has been, the school certificate was obtained in 2000. Obtained, my lord, the. Obtained in the year 2014, 6/6/2014. And here, the certificate, my lord, which was issued on 6/6/2014, it was in the name of Alexander Nessa, daughter of Alexander Khatun, sorry, Alexander Khatun, and daughter of late Abdul Dulal. And as per this record, as per this certificate, my lord, she was studying in the school and left the school in 1987. And if it is the certificate given on the basis of record, your lordship will find in 1993, father was alive. And this certificate shows the father was died, father is late Abdul Dulal. That means in 1997, if it is given from the school record, the record says, my lord, Abdul Dulal was no more in 1987. Because certificate cannot be issued, but even though it is issued, it has to be issued on the basis of record, which is available in the school, my lord. However, this is not proof. This document is not proof. And this is further not admissible because the school headmaster is not competent to emboss the national emblem in his certificate. So the national emblem is embossed in the top of this certificate issued on 6/6/2014. For these two reasons, first of all, it is not proved by the issuing authority. Secondly, the national emblem is embossed in the top of the certificate, so it is not admissible. So on both this ground, this certificate is not acceptable as a piece of evidence. Now, so, my lord, apart from this, there is no documentary evidence to show her link along with her projected father. So only boils down, my lord, the evidence of BW2, the projected murder, whether the oral evidence of the murder can be accepted as a valid piece of evidence. For that, as I have already submitted, my lord, the mother herself, her citizenship itself is not clear because she herself could not produce any document. So her evidence should be seen very carefully, and that, in my humble submission, it may not be accepted because she herself could not produce her citizenship certificate, my lord, any documents of her citizenship. So my learned friend was relying on that, my lord. Last occasion, relying on a voter, probably this is 2023 GLT 816, giving stress to this case, my lord. Karim Ali.
2013 1 GLT.
2022 3 GLT
816.
816. This was relied on. And this is, in fact, my lord, even though, my lord, this case was, we have some observation on this, my lord. But in that case, it was totally a different issue. There, my lord, your lordship will find, I have argued yesterday also, one point, that the oral evidence, in absence of documentary evidence, relating to the parents and the son, the petitioner, and the man who has come forward for giving evidence, that cannot be accepted. That is the point. In the present case, the petitioner's father has come, mother has come. Mother and the petitioner has no documents at all, link documents. But in that case, my lord, there was a document where the mother came, and mother and this son has a documents linking themselves. That is totally different from the present case, my lord. Your lordship will find in that case, my lord, para 6, the facts has been given.
Okay.
Para 6 is, the fact has been given. So it is.
Yesterday you have pointed out that.
Yes, madam. No, this is in the present, my lord, in 22 3 GLT 816. In that case, the situation has been described, my lord. In that case, my lord, which my learned friend is relying on. What is their case, my lord? On para 6 in the middle portion, my lord. Exhibit D is a copy of middle school English school living.
See, in fact, this judgment after which you have pointed out the discrepancies,
Yes.
is favoring you.
Yes,
Favoring you.
this is
Otherwise,
favoring. Yes, this is
there is
favoring me.
something in the judgment which you should read very minutely.
Yes. No, that's why.
While discussing, brother has pointed out a particular paragraph. And that day, Mr. Hussain was going pointed out.
Yes. This is clearly said, my lord. In that case, father and mother and the first son had a link document.
No,
But-
the thing is this.
And there was no
that
discrepancies
judgment
at
which
all.
you have Placed yesterday.
Yes, my lord.
That the oral evidence wouldn't be enough. It
Yes,
has
madam.
to be have because there are two judgments.
Two
One is
judgments, madam.
judgment, the second judgment,
Second
which you
judgment.
have said,
Yes,
and that has to be a which reliable document.
yes, my lord.
That what in the second judgment,
Yes, it is clearly said. my lord.
it was stated, that is 2000, that is WPC, Asia Khatun's case.
Yes. 402017.
4020-2017, it was clarified that it has to be with reliable documents.
Yes, ma'am. So indeed,
Now, even this case of Karim Ali,
yes, my lord.
the
There
same
were
thing has
documents.
said.
There are documents that Karim Ali had some documents along with that, my lord, the mother. That's why that may be acceptable, my lord. But in the present case, there is no documents at all along with the petitioner and the mother.
Okay. Anything else?
My lord, just I'm pointing out in that only one line, man. Exhibit A is the voter list of 1999, in which the name of the petitioner appeared along with the father and mother of the under Paschim Matia village, Gwalpara district. In that case, In the present case, there is no such link document. That's all, my lord. And my lord, my submission is that, my lord, as from the 2023 SSC Online 996, the Supreme Court's on, my lord, certiorari jurisdiction. In certiorari jurisdiction, my lord, we may not reappreciate the evidence given in the, my lord, tribunal. We may not go for reappreciation of the evidence of the tribunal. It is the tribunal who is to give the final opinion, and the facts, my lord, which is determined by the tribunal is final. We may not reappreciate the facts. We are here to look whether the tribunal has committed any error apparent, or whether the tribunal has not given any, my lord, any chance to the petitioner to adduce evidence, or the evidence the tribunal has gone beyond the evidence and passed the order. That must be. We cannot reappreciate the evidence, reappreciate the facts, which is determined by the tribunal. So that is under the certiorari. We are under certiorari jurisdiction. That's my humble submission.
May it please your lordship. Lordship, very rightly pointed out, your lordship. I'm only pointing out the legal infirmity, your lordship. I'm not pointing out, I'm not expressing this court to reappreciate the evidence, your lordship. Your lordship, now going from
Your case is that as per section 50 of the Evidence Act,
your lordship.
the oral evidence
Yes, your lordship.
produced by the projected mother of the proceeding
Lordship.
is sufficient to prove that she is the daughter of Abdul Dulal, or at least is the daughter, her daughter.
Lordship.
And her name figures in the voter list of 1977.
Lordship.
So, necessarily, that part of the evidence seduced by the DW2 is sufficient to prove the nationality of the proceeding,
Lordship.
considering section 50.
Lordship.
And your case is that the proceeding is required to prove, though section 9 of the Foreigners Act specifies, it is the evidence not beyond reasonable doubt, it is only the preponderance of probability. That's right. And to that extent, the petitioner or the proceeding could prove that DW2 is her mother, and she has sufficed that she is her daughter.
Lordship.
Anything else?
Lordship, now my learned friend on the other side has pointed out something regarding the voter list also. Your lordship, I would like to clarify that, your lordship. Your lordship, though we somehow agree, your lordship, that the cases under Foreigners Act 1949 has to be established under the theory of preponderance of probability. But somehow down the throat, your lordship, there is an environment in the tribunal, your lordship. It has to be proved beyond reasonable, it has to prove beyond doubt, your lordship. That is the reason. Now, your lordship, the things that has been pointed out, your lordship. Again, these things are covered by Sirajul Haq, passed by the Supreme Court, your lordship. Now, if your lordship may move on to the voter list of 1965, your lordship.
See, basically, Sirajul Haq, which most of the councils appearing for the petitioners are placing, there the lordships in the Honorable Apex Court have considered few aspects. It was a matter where only one particular letter of a word was found missing, Afatullah, Amatullah, and Kamatullah. But what was the finding of the Honorable Apex Court? You see at that particular thing.
Lordship.
The names of the persons above that name and below that name were remained constant. Only the particular word was different.
Your lordship, but there was also an observation that there may be
Perhaps
variation of name, age, and even shifting, your lordship, but that doesn't make a person foreigner, your lordship.
That definitely, see, it is a, what is para 3, if you read of that judgment,
Lordship.
that is in the context of that particular
Yes, your lordship.
case. It is not applicable for all.
Lordship.
See, basically, regarding shifting and other things were not at this moment. In the right case, we will place it. But here, But the case of Kefatullah, Kematullah, that's
Lordship.
his case.
Lordship.
Only because that letter was found missing, basically. That is why the Honorable Apex Court came to that conclusion. And everything is passed, that you have to see the background of a case. Simply because coming on that, we don't rely on it. Now, you have the Karim Ali with you.
Yes, I've got the Karim Ali.
Just explain it to us. What do you mean by the observation made by the coordinate bench earlier
Lordship.
at para 46? Read very slowly and
Lordship.
tell us, explain.
In this regard, it may be noted that the standard of proof on the basis of which a property is required to discharge his burden
Slowly.
discharge his burden under Section 9 of the Foreigners Act 1946 is preponderance of probability and not proof beyond reasonable doubt. In other words, if the proceeding is able to show the high degree of probability of being a citizen of this country based on credible evidence, it can be said that he has discharged his burden. Your Lordship. The law nowhere requires that a person has to discharge his burden on the basis of proof beyond reasonable doubt. Thus, by applying the said principle of preponderance of probability, we can examine as to whether the petitioner has been able to discharge the burden of or not. Your Lordship, credible evidence has to be given.
Now, please read section 9 of the Foreigners Act.
Lordship, burden of proof. If in any case not falling under Section 8, any question arises which refers to this act or any order made or direction given thereunder, whether any person is or is not a foreigner, or is not a foreigner of a particular class or description, the onus of proving that such person is not a foreigner or is not a foreigner of such particular class of or description, as the case may be, shall not withstanding anything contained in the Indian Evidence Act 1872 lie upon such person.
So basically, this indicates that whatever is in the Evidence Act
Lordship,
will not be applicable,
Lordship,
right? But to prove,
Lordship,
it has to be proved, it is the burden lies on the proceeding to prove.
Lordship.
By what? By what?
Your Lordship, I have to adduce evidence.
There is evidence, but by what he has to produce? It is the burden is on the proceeding to prove.
Procedure, Lordship.
In what manner?
Well, it has to be proved as per Evidence Act, Your Lordship.
Now, that is why we ask you on
Lordship.
that day, if let us assume a person A projected mother or father
Lordship,
appeared before the tribunal saying that he is my son or she is my daughter.
Lordship.
Right? Will that be sufficient? Even under Section 50 of the Evidence Act. For that, what will be the duty of A?
Your Lordship, for that, Your Lordship, I will again rely upon the judgment of Karim Ali. And Your Lordship, under Section 50.
No, that is why I'm asking you.
Your Lordship,
You are right.
I have.
So probably let us say in that way, it is not beyond reasonable doubt.
Your
But even
Lordship,
then,
Lordship,
even then, on what basis? Because it's just like that. If a person is saying a wrong thing for 100 times,
Lordship,
then it will become correct.
Lordship.
If the procedure for 100 occasions saying that A is my father or A is my mother, and A comes before the court and saying that she is my daughter or he is my son, will that be correct?
No, Your Lordship.
Then what will be the proposition of
Lordship.
A? How A will adduce the evidence on behalf of the proceedee to say that he is her son or she is her daughter? How?
Your Lordship, before going to that,
Hmm.
Your Lordship, I will go to Section 59 of the Evidence Act. Proof of fact by oral evidence. All fact except the contents of documents or electronic record may be proved by oral evidence. Now I was born from my mother's womb. It has got no electronic record. Yes, there could have been a documental record if I had a birth certificate. And I have explained, Your Lordship, in the earlier hearing, the Register of Birth and Death Act took place in the year 1969. It was made applicable in the year 1977. And in 1993, it was made compulsory in the state of Assam.
Hmm.
Even in the year 2000 and 2001, Your Lordship,
Hmm.
during the Sarva Shiksha Abhijan, when there were low turnout of students because of birth certificate,
Hmm.
students were given admission without.
We
this
understood many,
Your
even
Lordship.
my parents doesn't
So-
had birth
Yes,
certificate.
Your Lordship,
Right, right.
many parents, Your Lordship, my father also don't have a birth certificate, Your Lordship. So, Your Lordship, based on this, Your Lordship, there is no other documents we can. Based on this, Your Lordship, it cannot be expected, Your Lordship,
Rightly.
to
That-
manufacture a document
Hmm.
which doesn't exist.
Now, just that is.
Now, Your Lordship, so
That
the-
is why if somebody appears and say before the tribunal or before the court gives an evidence
Lordship,
that he is my son or she is my daughter, will that be sufficient?
Your Lordship, if Your Lordship, this evidence become relevant if it satisfies section 50 of the Evidence Act, Your Lordship.
Read section 50.
Section 50, opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship or any person who as a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. Provided that such evidence, opinion shall not be sufficient to prove a marriage in proceeding under the Divorce Act 1960.
Hmm.
This is the different thing, Your Lordship.
So,
Now, Your Lordship,
Hmm.
in Karim Ali, Your Lordship, those facts and circumstances have been different.
Hmm.
In para 51,
Hmm.
52, it has been widely discussed. The ratio has been laid down, Your Lordship. The evidence of the petitioner's mother, in our opinion, is highly relevant, if Your Lordship is perusing it,
Hmm.
and significant, who testified from her direct knowledge about she being married to petitioner's father and about shifting to different villages along with her husband. And also the testimony about the children born to her and the particulars of our other relatives. Certainly, the evidence of Kadbanu Nessa, the mother of the petitioner, that the petitioner is her son, is a direct evidence. It will be from her direct knowledge as the mother. As the evidence of the petitioner's mother, Kadbanu Nessa, who testified as DW3, was not shaken during cross-examination, it has to be given the credibility it deserves. In the light of the other evidence, both oral and documentary. In this regard, one may refer to Section 50 of Indian Evidence Act 1872, which provides that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. Kadbanu Nessa, who the petitioner has projected to be his mother, has in clear terms testified before the tribunal on many personal and private incidents relating to her marriage to Asaduzzaman and staying of her husband as her Jamai, shifting to different villages, and about other relationship of both her father, Abdul Ghani, and various other relatives. The detailed rendering of the accounts relating to the family of the Sheikh Kadbanu Nessa, who has a special means of knowledge, has not been really taken in course of cross-examination. Her testimony read in conjunction with other documentary evidence exhibited as referred to above would, in our opinion, clearly corroborate and substantiate the claim of the petitioner that the petitioner Karim Ali at Abdul Karim is the son of Kadbanu Nessa and Asaduzzaman, as such an Indian citizen. So, Your Lordship, in this case also, Your Lordship, the evidence is made by a mother. It is from her direct knowledge. Your Lordship, to substantiate this, Your Lordship, I have submitted a order of the Honorable Supreme Court, Dol Govinda Parishad. Today, I am submitting another order, Your Lordship. It is of 2000. It's Bant Singh, Your Lordship, and another. 2008 for SCC 75. Bant Singh today.
2008
for SCC 75. Your Lordship, the relevant person starts from para 20, Your Lordship.
Yes.
DW1 at the time of his deposition was aged 80 years.
Hmm.
He is the brother of Baksa Singh, husband of Nandi. He proved the genealogy of the family of Sartu. Nandi was the wife of his brother. He therefore had special knowledge in regard to relationship between her on the one hand and Munshi and Bakhtawar Singh on the other. He attended the marriage of Nandi. Bakhtawar and Munshi, according to him, used to come to their house. The relationship between the appellant and the said Munshi Singh and Bakhtawar Singh was thus within his special knowledge. He categorically stated the manner in which the appellant used to be treated by Munshi Singh and Bakhtawar Singh. In answer to a question put on to him in cross-examination, he, in no uncertain terms, categorically stated that he had heard as well as saw Nandi calling Munshi Singh and Bakhtawar Singh as brothers. He attended the marriage of Nandi when he was only 15 years old. To the similar effect is the evidence of DW2 Hajura Singh, who was another brother of Baksa Singh. He was aged 75 years on the date of the deposition. DW2 is a resident of the same village. He had also watched the parties from a close quarter and thus could depose about the conduct of Nandi vis-a-vis Munshi Singh and Bakhtawar Singh. He, apart from other things, testified that Bakhtawar Singh had come to attend the marriage of Bachchan Kaur. He stated in details about the family of both the parties. He deposed that he had old dealings with Baksa Singh, being of the same village. He also attended the marriage of the brother of Baksa Singh, being a close relative. In Dol Govinda Parishad, this court relied upon the evidence of two witnesses who had attended the marriage of Haripriya and Loknath, which was in dispute. In that case, the relationship of Ahalya and Malavati as the daughter of Loknath was in dispute. Interpreting Section 50 of Evidence Act, this court held that on a plain reading of the section, it is quite clear that it deals with relevancy of a particular fact. It states, in fact, that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who has special means of knowledge on the subject of that relationship is a relevant fact. The two illustrations appended to that section clearly bring out the true scope and effect of the section. It appears to us that the essential requirement of the section are, number one, there must be a case where the court has to form an opinion as to the relationship of one person to another. Two, in such a case, the opinion expressed by conduct as to the existence of such relationship is a relevant fact. But the person whose opinion expressed by conduct is relevant must be a person who, as a member of the family or otherwise, has special means of knowledge on the particular subject of relationship. In other words, the person must fulfill the condition laid down in the later part of the section. If the person fulfills this condition, then what is relevant is his opinion expressed by conduct. Opinion means something more than mere retelling of gossip or of hearsay. It means judgment or belief. That is a belief or a conviction resulting from what one thinks on a particular question. Now, the belief or conviction may manifest itself in conduct or behavior, which indicates the existence of the belief or opinion. What the section says is that such conduct or outward behavior as evidence of the opinion held is relevant and may therefore be proved. It was further held, and so, if we remember that the offered item of evidence under Section 50 is conduct in the sense explained above, then there is no difficulty in holding that such conduct or outward behavior must be proved in the manner laid down in Section 60. If the conduct relates to something which can be seen, it must be proved by the person who saw it. If it is something which can be heard, then it must be proved by the person who heard it, and so on. The conduct must be of the person who fulfills the essential conditions of Section 50, and it must be proved in the manner laid down in the provision relating to proof. It appears to us that a portion of Section 60, which provides that a person who holds an opinion must be called to prove his opinion, does not necessarily delimit the scope of Section 50 in the sense that opinion expressed by conduct must be proved only by the person whose conduct expresses the opinion. Conduct as an external perceptible fact may be proved either by the testimony of the person himself whose opinion is evidence under Section 50 or by some other person acquainted with the facts which express such opinion. And as the testimony must relate to external facts, which constitute conduct and is given by person personally acquainted with such facts. The testimony is in each case direct within the meaning of Section 60. Thus, in our opinion, is a true interrelation between Section 15 and 60. Applying the aforementioned test in regard to the evidence of Janardhan Misra and Dharanidhar Misra, the two witnesses who were examined to prove the relationship between Ahalya and Malavati, it was opined the first question which we must consider is if Janardhan Misra and Dharanidhar Misra has special means of knowledge the disputed relationship. Janardhan Misra was aged about 62 in 1946, and he was related to the family of Baidyanath Misra. Kasinath Misra was his grandfather and was a brother of Baidyanath Misra. Obviously, therefore, Janardhan Misra has special means of knowing the disputed relationship being related to Baidyanath and therefore to Haripriya, who was the second wife of Loknath. He said in his evidence that he knew Loknath Parisha. He had seen his first wife Satyabhama and remembered the marriage of Haripriya and Loknath Parisha. Obviously, therefore, he fulfilled the condition of special marriage. He further said that he attended the marriage of Malavati, daughter of Loknath, while Loknath was living. That marriage took place in the house of Loknath. He also said that he was present when the first two daughters of Malavati were married, and also at the time of the Upanayan ceremony of plaintiffs, 1 and 2. According to the witness, Syam Sundar Pujari, a son of a sister of Loknath, acted as a maternal uncle at the time of the marriage of the eldest daughter of Malavati, and Dayasagar Misra carried Radhika, second daughter of Malavati, at the time of her marriage. In Santinath Ram Danole versus Jambu Ramu Danole and Munsi Das versus Malsingh. Applying the same test, we have no doubt that the evidence of DW and DW2 are admissible in evidence, being in conformity with the provision of Section 50 of the Evidence Act. It will be a repetition to state that the High Court, for the reason best known to it, did not advert to the deposition of the witnesses examined on behalf of the appellant at all. The High Court could have interfered with the finding of fact in a second appeal, provided it applied the right test, but it failed to do so. So, Your Lordship, this is here in this case, Your Lordship, some other members of the family were testifying, Your Lordship, that they had this relationship, we have attended their marriage, so we know. Now, this is from the direct knowledge of the mother. So I repeat, Your Lordship, the petitioner herein got birth in the year 1979, as per her evidence. In the voter list of 1977, Your Lordship, her father and mother were shown as parents, Your Lordship. So, Your Lordship, during the sustenance of this marriage, she was born. Again, Your Lordship, the paternity of the petitioner has been proved as per Section 112 of the Evidence Act, Your Lordship. And Your Lordship, in Sirajul Haq, Your Lordship, if Your Lordship go to the facts of the case, Your Lordship, it was seen that the grandfather's name appeared in the voter list of 1966-70. Father's name appeared in the voter list of 1997, Your Lordship. There is nothing, Your Lordship, on record in this order, Your Lordship, that there was some other voter list in between them. We don't know. But here, Your Lordship,
But in Sirajul Haq,
Your Lordship,
the grandfather's name, the father's name figured together in the
No.
1997 later part
Lordship,
after 1970.
Lordship,
And grandfather's name figured prior to 1970.
Your Lordship. But in this case, Your Lordship, my grandfather's name and my mother's name figured together in the voter list of 1977. Your Lordship, in the voter list of 1965, Your Lordship, my grandfather's name appeared. His son is the son of Muhammad Ali. Now, Your Lordship, when we apply for the voter list, Your Lordship, when we apply for the voter list, sometimes you get a full list, Your Lordship, containing the name of the entire family members. Sometimes you get one or two names.
It's not like that. Of whom you want, you will get.
Yes, Your Lordship. I have applied for my grandfather. My grandfather's voter list name comes, Your Lordship. Thereafter, I have applied for my father, Your Lordship, the voter list of 1977. In the voter list of 1977, Your Lordship, my grandfather's father was shown to be Muhammad Ali. The village is same. Your Lordship, Moza is same. Everything is same, Your Lordship. My grandfather's name is there. My father's name is there. My mother's name is there. Your Lordship, my grandfather's name continues to continue, and then there Akel Ali name whose name is there in the voter list of 1965 gets enlisted in the voter list of 1977. He's the son of Muhammad Ali, and he is from
How
the
many
same
Manas is there in the Guwahati High Court?
Lordship.
How many Manas is there in the Guwahati?
Your Lordship, there can be, Your Lordship. Your
No,
Lordship.
no, I'm asking you, how many Manas is there in Guwahati?
Your Lordship, there can be many, Your Lordship. There can be many.
So the same person whom you are projecting
Lordship.
from that particular village, there may be many. How you are so sure that this particular father, projected father of the proceeding, father is the same man whose name figured in the voter list of 1996.
1966.
66.
Your lordship, ifs and buts, your lordship, it is difficult to
That is the
prove.
reason we are asking.
Your lordship, it is, your lordship, but what, your lordship,
How you relate
your lordship,
that, see, the voter list has many important things.
lordship,
Not only name of the village name may be common,
lordship,
village name may be common.
lordship,
Something is very common, village name may be common, like in the village Luzan Bazar or Lotus Hill, Pan Bazar, you will have many persons,
lordship,
same name.
lordship,
That is why I ask you,
lordship,
my name, how many persons are there in the Guwahati? You'll find many.
lordship.
I can show you Manas Sorenia, Manas Haloi, many are there.
Yes, sir.
I was also there at one point of time,
Lordship.
right? In the Guwahati High Court, you'll have many man.
Lordship,
So things are like that. First of all, you have to prove.
lordship,
And while discussing all these facts,
lordship,
at para 46, the coordinate bench have made it very, very specific.
lordship,
That the evidence should be what? Evidence should be. What is the judgment? Not necessarily that beyond reasonable doubt. It may be preponderance of probability, but
credible.
based on credible evidence.
Yes, your lordship,
What is that credible evidence? It is the tribunal
lordship,
will form its opinion,
lordship,
right?
lordship,
That what is credible evidence and what is not credible evidence.
lordship,
Here is a voter list of 1966,
lordship,
right? And in 1977,
lordship,
the next voter list
lordship,
has been pointed out by Mr. Payeng.
lordship,
What he has pointed out is that in 1966 or 1965 voter list,
lordship,
one Akel Ali,
lordship,
son of Muhammad Ali, aged about 53 years,
lordship,
was residing in the house number 105 at village Kotayani, whose name figured in the serial number 310. From Roha constituency.
lordship,
Yes, on Akel Ali, there is there at 105 house number.
lordship,
Everything is fine. Who was aged about 53. The next voter list you are relying is of 1977,
lordship,
which consists of a name of one Ake Ali,
lordship,
not Akel Ali, Ake Ali,
lordship,
son of
Muhammad, your lordship,
Muhammad. Where proper nouns we are not on that.
lordship,
See, Akel Ali and Ake Ali is one drop of name. If you are saying Sirajul, fine. Then Muhammad, that is also Ali's job, fine. But just see, you said your grandmother is Amina. You said your father is Dulal Mia. You said your mother is Anwara Begum, right?
lordship,
Look at the house number, look at the age difference between your grandmother and your father.
lordship,
Look at the age of, let us assume it is Akel Ali, the person concerned whose name figured in 1966. What was his age in 1966 and what was his age in 1977?
lordship,
Now, even if it is, we have to follow the preponderance of probability, we cannot just brush it out that it should not be credible evidence. You have to adduce the credible evidence to prove. That's what Mr. Payeng has pointed out. Right. Now, You have also pointed out, you have annexed, you have reduced a voter list of 1993,
1977, and then 93. Yes, 93.
1993.
Lordship,
It has a altogether a different name of one R. Dulal,
Lordship,
whose father's name is Behel,
Lordship,
who is of 36 years.
Lordship.
Then one Anwara Begum, wife of R. Dulal, that is Abdul Dulal or whatever, who is 32 years in 1993, whose name figured in the voter list of 1977 as the wife of Dulal,
Lordship,
is it about 28 years?
Lordship,
So thereafter again a voter list of 1997.
yes,
Now there is Anwara,
Lordship,
whom you are claiming to be your mother.
Lordship,
Now this time she has become 35 years in 1997.
Lordship,
But who was only 19 in 1970, 1977, she was already 30, already 28 years.
Lordship.
So where is that credible evidence?
Your Lordship, my humble submission in this regard, Your Lordship. There can be coincidence, Your Lordship. There can be one name here and there. There can be multiple names, but there cannot be many coincidences, Your Lordship. The mistake committed by the respondent authorities may not be attributed to me, Your Lordship. And
Why-
Your Lordship,
why? See, basically,
yes, Your Lordship.
who is relying on these documents?
Yes, I am relying on these documents.
Now,
Your
if you are relying on those documents, that you have to accept in toto, not in part.
Your Lordship, Your Lordship, I am relying on the documents that were in public record.
Hmm.
I do not, Your Lordship, make these records, Your Lordship. I get these records, Your Lordship.
Mm.
And there are hundreds of cases, Your Lordship. If Your Lordship wants me,
So
I'll
it
file
is-
an
if
affidavit.
somebody-
I'll
if
file
it
an
is-
affidavit, Your Lordship. There
that
are
is-
hundreds of cases, Your Lordship.
See, that is all we know. But if you are relying on some particular document,
Lordship.
first of all, you have to rely it as a whole, right?
Your
You
Lordship,
cannot just speak and say that this is belongs to my father, this is my mother, name goes together.
Lordship,
That you cannot do.
Your Lordship, I am relying on the entire documents.
So-
Here in the voter list of 1965, my father name is Akhil Ali. He belonged from the village of Kutioni. And his father name was Muhammad Ali.
That's
Your
it.
Lordship, now village name and father's name, or not only my grandfather's name, Your Lordship, carries to the voter list of 1977.
Hmm.
It is my great grandfather's name, as well as my village name, that also gets carried to this.
Right.
Your Lordship, now, if Your Lordship compare the voter list of 1977 and 1993,
Hmm.
Your Lordship will see, along with Dulal Mia and Anwara, there is another name named Abdul Hassan. Your Lordship, that name also gets carried to 1993 voter lists. It cannot be coincidence, Your Lordship, because the village remains the same. The LSC remains the same, the Moja remains
We
the
are
same.
asking you, that is the reason we are asking you. We are asking you for that reason. Similar persons available in the voter list, there are many you'll find. But something has to be common.
Your
Something
Lordship,
has
the
to be common.
commonality, I'm pointing
Now-
out to the commonality, Your Lordship.
Mm.
I'm saying, Your Lordship, the commonality, Akhil Ali may be different, Your Lordship. There may be two Akhil Ali, Your Lordship.
Hmm,
Village may be also same.
right?
Then again, my father's name will, my great grandfather's name also becomes the father. Now, Your Lordship, the weightage of evidence, definitely, Your Lordship, is on my side.
Mm.
My humble submission is that, Your Lordship, because there are more commonality than disagreement that can be brought out, Your Lordship. And in that with due humble submission, Your Lordship, in the voter list of 1977 to Your Lordship, I am saying that Akhil Ali, Dulal Mia, and Anwara Begum names are there. But there is another name, Your Lordship, Abdul Hassan. And this name again appeared in the voter list of 1993. It cannot be all coincidence, Your Lordship. There is difference in age, Your Lordship. If Your Lordship permit me, I am ready to file an affidavit, Your Lordship, annexing many documents of many cases, Your Lordship, where Your Lordship will find similar, Your Lordship, problems, Your Lordship, regarding age, and Your Lordship will find out from the record itself, Your Lordship, these are faults committed by the Election Commission, Your Lordship. And in the voter list of, if Your Lordship carry on from 1993 to 1997, in the 1993-97, Abdul Dulal and other name disappeared. But here, along with Abdul Dulal and Anwara, my brother's name Fakhruddin appears.
Hmm.
Again, in the voter list of 1997, Fakhar appears, Your Lordship.
Hmm.
And regarding, Your Lordship, the age, there is discrepancy of age. Your Lordship will see in the 1993 voter list, Your Lordship, Fakhruddin name is 20, age is 22. Again, 97, the age is 22.
So it will be credible evidence of whom?
Your Lordship, this is the evidence, Your Lordship, I have been adducing. Your Lordship, these are not evidence, Your Lordship, with humble submission.
Who is required to prove credible evidence?
Your Lordship, I have to prove, Your Lordship. The evidence that I can prove are the voter list,
See,
are the land
basically,
documents.
credible evidence have to be credible evidence.
Lordship,
And that is why thing is this, only by marrying, saying that somebody is my son, somebody is my daughter, without having such credible evidence, will be accepted. Tell us.
Your Lordship, regarding the credibility of evidence, Your Lordship, there is no law laid down, Your Lordship, which evidence can be said to be credible, Your Lordship. Your Lordship, yes, Your Lordship, in some other case when I was arguing, Your Lordship, Justice Bujal Bora, Your Lordship, just pinpointed out one thing. Your Lordship, perhaps they sought some idea from the other side. Can we go to an extent to do DNA testing? Is it feasible? So, Your Lordship, if we want to prove these cases beyond doubt, beyond reasonable doubt, Your Lordship, some scientific arrangement has to be adopted, Your Lordship. Because, Your Lordship, here, Your Lordship, I have been saying again and again, Your Lordship, and Your Lordship, may appreciate, Your Lordship, Akhil Ali, have his father's name, continues in a subsequent voter list. The other name, along with Akhil Ali, Abdul Dulal, Dulal Mia, and Anwara Begum, this name again continues in the subsequent voter list of 1993. And again in the voter list of 1997, there are other names which continue from the voter list of 1993.
Okay, enough. Listen. Heard. Mr. Rai Hussain, learned counsel appearing for the petition of. NMS RDV unit, CZC for the restaurant number 1. Also heard Mr. J. Kwang, Standing Counsel from Department Assam for the restaurant number 2 and 6. Mr. Anyone from election AI Ali, Standing Counsel Election Commission of India for the restaurant number 3. And Mr. H. Kahlikal and Government of Assam for the restaurant number 5. Records. Mr. Sharma records.
Yes.
Where is the record?
Yes, Lord.
Of FP case number 69/2017. Wherein the learned Fairness Tribunal Gaspur First Sonitpur passed the impugned judgment dated 29/10/2020. Opining the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered into India on or after 25/03/1971 without any valid documents. So, in support of the petitioner, Mr. Hussain, learned counsel, amongst others, relied on the decision AIR 1959 SC 914-1234 degree 2 2008 4 SCC 75 2000 Sirajul Haq decision. Just give us the citation.
Lordship, Sirajul Haq, 2019, 5 SCC, 534. Your Lordship, there is another similar case with, Karim Ali, Your Lordship, Sujab Ali, Your Lordship, that is 2021, 4 GLT, 664.
4 GLT
664, 2020,
6.
664, 2021, 4 GLT, 664.
2013 1 GLT 941. 2021 4 GLT 664. 2022 3 GLT 816. The provisions of section 50 as well as section 59 and section 112 of the evidence section. On the other hand, Mr. J. Pang, Standing Counsel, Home Department, relied on the decision of the Honorable Supreme Court in the case of Sarvando Sonowal 1, 2005 Paradi decision, as well as a decision of this court in the case of Asia Khatun versus Union of India, decided on 21/11/2019 in WBC number 4020/2017. Arguments are heard. Order is up. Second, single bench or Manu, sir. Oh. Yes, 3:30. 13 or 5 minutes past minute.
Like,
Here in this matter, I was instructed to provide build an instruction your lordship, but I have not received your lordship. It's a short date, your lordship.
Give us a date.
By evening, maybe it's tomorrow. By evening, I will.
Tomorrow may not be possible, Mr. Deori.
Yes, thank you, lord.
6th,
Much obliged.
on the prayer of Mr. B. Deori, Landed Government Advocate Assam, matter be taken up on 6th of June. You are appearing in this case.
Lordship, I'm appearing for the education department, your lordship.
So for the education department. Whether she joined the school,
Lordship, actually, I didn't have the instructions today, your lordship.
find out whether the petitioner has joined the school or not. Because she did not join the school.
Yes, your
She
lordship.
has also admitted here in this petition that since the case was pending
Yes, your lordship.
and she did not join. There was a question of not joining the school doesn't arise. During that period, she was rendering her service in another school because in the affidavit, it was very much written. Anyway, find out this case was already disposed of on 17th August.
Yes, your lordship.
2023. And this petition was filed in this review petition was filed in 2024.
Four.
In between whether she has joined and to my knowledge, just that is why I was reading. Some proceeding was initiated against the petitioner. Because a new principal came to the school and just on the pretext of some sexual abuse, she left the school. And that is why she was working in another school, higher secondary school, and that was pointed out. So we're fixing it on 6th, the other side is not here.
Yes, your lordship.
But get the information whether she has joined after filing of this review petition on this review petition was filed. Because the petition was dismissed on 17th of August.
17/8/2023, your lordship.
Thereafter, she has joined or not, this CBS high school, and if she has joined, when did she join? Now, what is about her present status?
Yes, your lordship.
Whether she is getting salary or whatever, everything you give it to us.
Yes, your lordship.
But we will not give you much time. 6th, you have to give it to us.
Okay, your lordship.
As paid for list on 6th. Absolutely.